You're with Dr. Nita Chhinzer, and in this episode we will be discussing what's considered employment discrimination legally under the human rights law in Canada. Central to human rights laws in Canada is the concept of discrimination, referring to unfair or prejudiced actions based on prohibited grounds. Which conditions are protected varies based on jurisdiction. Recall, there are 14 different jurisdictions in Canada, a federal jurisdiction, 10 provincial jurisdictions, and 3 territorial ones. However, there are some similarities between these. For example, across jurisdictions in Canada, all of them have legislated protection against discrimination based on age, race, color, sex or gender, mental or physical disability, sexual orientation, place of origin, and nationality. In most jurisdictions, protection against discrimination based on marital status, family status, religion, source of income, gender expression, ethnicity, language, creed, and ancestry is provided. And in some jurisdiction, employees are protected against discrimination in employment decisions based on their political beliefs or activities, criminal convictions, or social conditions. However, employers are permitted to discriminate if the employment requirements are based on a bona fide occupational requirement. This is defined as discrimination based on a business necessity. For example, a person who's blind cannot be employed as a truck driver or a bus driver. Or when casting for a theater show, there may be specific roles that justify using age or ethnicity as a recruitment and selection criteria. In fact, the Supreme Court of Canada has established 3 criteria to assess if the discrimination in employment qualifies as a bona fide occupational requirement. The first criteria is the question of rationale. Was the policy or procedure that resulted in the discrimination based on legitimate work-related purposes? The second criteria is the question of good faith. Did the decision makers or other agents of the organization honestly believe that the requirement was necessary to fulfill the requirements of the role? The third is the question of reasonable necessity. Was it impossible to accommodate those who have been discriminated against without imposing undue hardship? The big question is, how are we doing? The Canadian Human Rights Commission oversees human rights violations. They have less than 200 employees, and we have stats from 2022 that are quite telling. Over 46,000 people contacted the Canadian Human Rights Commission for help in 2022, of which 763 complaints were accepted. Of the accepted complaints, 41% were related to disability, 31% were related to race, color, nationality, or ethnic origin, and 19% were related to sex. In fact, roughly 1 out of every 3 cases included more than one ground for discrimination. The number of complaints received indicates that employees experience and question discriminatory practices in Canadian workplaces. For the employer, the results indicate a need for them to reevaluate and improve accessibility and inclusion of persons with disabilities. Moreover, although Canada is a highly multicultural society, workplace policies, procedures, and outcomes should be established and reviewed to ensure that employees' race, ethnicity, place of origin, and nationality do not result in employment inequities. These are the current areas for improvement in Canadian workplaces.